Freya, can you hear me? Can anyone hear me?
Yeah, I can hear you, Paula.
Thank you. Appreciate it.
You bet. All right, sounds good. Are we recording? All right, thank you. Good morning, everyone. It is 8:58 a.m. on November the 20th. This is the second regular docket of the Oil Conservation Division's monthly hearings. We are hearing status conferences today, and we are going to begin with 4 cases that are joined together. 2 Matador cases, 25595 and 96, and 2 Earthstone cases, 25717 and 18. Entries of appearance, please.
Good morning, Jackie McLean on behalf of Earthstone Operating.
Good morning.
Good morning, Mr. Hearing Examiner.
Morning, Ms.
Sorry.
Vance.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador Production Company and the Dick Jones cases.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating and Cimarex Energy Company of Colorado.
And what is your position?
We objected to all 4 of these cases, and Coterra is planning on filing competing applications. These cases are already set for a contested hearing on January 27th. And Coterra is planning on filing competing applications, which would be in time for the January 27th docket. But also between last night and today, Coterra and MRC reached an agreement. And MRC, it's my understanding, and I'll let Ms. Vance confirm that MRC is going to be dismissing its cases and supporting Coterra as operator moving forward. Coterra and MRC are working on a JOA that MRC is going to join and support Coterra. And so Coterra is hopeful that Permian Resources will follow suit and dismiss its competing applications and its objections, especially in light of the fact that MRC is going to be now supporting Coterra. And it's my understanding that Permian Resources has indicated a willingness to do so if Coterra is named as operator.
So what I understand so far from you, Ms. Bennett, is that you believe, based on a JOA, that Matador, well, I have Matador here. I don't know if it's Matador or not. Matador will end up dismissing its competing cases with Earthstone, and Coterra will be filing the competing cases with Earthstone.
That's right. Although hopefully Earthstone, which is also Permian, but Earthstone will be dismissing its competing applications as well, leaving Coterra the ability to move forward uncontested. That's Coterra's ultimate hope. And so it's my understanding that Permian Resources / Earthstone has indicated that it would dismiss its competing applications if Coterra were to be, if Coterra and MRC were to be aligned.
Okay, thank you. Are there any other entries of appearance?
Good morning, everyone. Sharon Shaheen on behalf of LFN Cone Properties and the estate of Kenneth G. Cone. We entered an appearance in the Dick Jones cases. We did not file an objection, and we are simply monitoring.
All right, thank you, Ms. Shaheen. Are there any other entries of appearance? No. All right, let's go back to you. Let's go back to you, Ms. McLean. Is this news to you?
Yes, yesterday,
I figured it was, yes.
Earthstone was saying they are ready to proceed forward with the January 27th contested hearing. And that's all I have for you today.
All right, sounds good. Do you know about any, were you aware of any of these negotiations between Coterra and Matador?
No, I was not.
Okay.
We've just been proceeding forward like we're
Right.
going to contested
All
hearing.
right. Did you know that it was Coterra's intent to file competing cases?
Yes, I
Oh,
think
you knew
Miss
that.
Bennett said that the last status conference, and so the client was aware of that. They had received proposals, and they at the time and as of yesterday were not wanting to join with Coterra or MRC, but I'm certainly going to take all this information back and see if their position has changed.
Ms. Vance?
Hi, good morning. Yes. I'll confirm what Ms. Bennett said. Matador, we are working on filing a motion to dismiss our cases, and that was going to be my update. And we have reached a agreement with Coterra, and we will be supporting, Matador will be supporting Coterra as operator in their
Okay.
proposals.
Yes, understood. Ms. Bennett, when do you believe you're filing the Coterra competing cases?
Thank you. I sent drafts to Coterra yesterday. The proposal letters were sent out on October 23rd. So I started working on the drafts of the application, so I should be able to file them either. It might be a push to file them this week, but early next week I would be able to file them.
Okay, very good. So then that would be on the early, I mean, if there were no competing cases, that would be on the early January docket for affidavit unless they're objected to, and then they'll be part of this January 27 contested hearing.
Yes, at the last hearing, at the last status conference, you asked that I join the Coterra cases with the competing cases.
Right.
And so, yes, I'll be requesting the first January docket with the understanding that if Permian does not withdraw its objection, then we will be moving to, Earthstone does not withdraw its objection or objects to the cases, that they will be heard as a contested hearing on January 27th.
Okay. But from your understanding, Coterra and Earthstone could not proceed by affidavit unless one of them dismisses.
That's right. These are overlapping,
They're overlapping.
Development plans.
And that's a curious word. When you say overlapping, you mean obviously competing, but overlapping is a different term, isn't it?
They're competing, but they don't have a 100% overlap. So it's not a 100% overlap. So there's some overlapping acreage. And I did draw a map, but I don't have it handy.
That's okay, I get that.
But yeah, that's, it's not a 1-for-1, in other words, as I recall.
Okay, perfect. All right, excellent. And when you do file your applications, let's say next week, would you file a motion to join them with and amend the pre-hearing order?
Yes, I will.
All right, perfect. Is there anything else?
Not for me. Thank you.
Ms. McLean?
Nothing from Earthstone.
All right, thank you. Ms. Vance?
Nothing from Matador. Will file that motion to dismiss today.
All right, thank you very much. We're off the record in those 4 cases. Let's move on to Waterloo Resources. This is 25602.
Good morning, Mr. Hearing Examiner. Caitlin Locke for the applicant in this case, Waterloo Resources.
Good morning.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2. And Avant has objected to this case moving forward by affidavit.
Thank you, Ms. Bennett.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Powderhorn, and Powderhorn has also objected to this application proceeding by affidavit.
Thank you.
Good morning, Mr. Examiner. Jordan Kessler on behalf of EOG Resources, and we've also objected to the application.
Yeah, I saw you objected. That's a novel. That's a novel one for you, isn't it?
Quite.
I thought it was, yes. Are there any other entries?
Yes, good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of Marathon and monitoring only.
Thank you.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador, who made an entry of appearance and objected. And also on behalf of Oxy, Oxy is just monitoring. We only entered an appearance on behalf of Oxy.
All right, thank you.
Good morning, Mr. Examiner. Miguel Suaza with Beatty and Wozniak appearing today on behalf of Riley Permian for purposes of monitoring and preserving rights only.
All right, thank you, Mr. Suazo. All right, Ms. Luck.
Thank you. This morning, I did receive confirmation, I think, from the last couple of parties that were involved in this case that I had requested everyone's concurrence before the hearing today about setting this for another status conference in December if possible, because I don't think this case is ready for a contested hearing. There's still been some trades that are ongoing currently, and I think it's in Waterloo's best interest to wait to set a contested hearing. So if we could have another status conference in December, that would be our preference, and look towards maybe the February contested hearing docket if possible.
Did you receive the list of possible hearing dates
Yes,
from Freya? You did. Okay, good. So I wanted to make sure you got that. I looked at my notes. This case was filed August 19. There are a bunch of objections. I realize that they're mostly negotiating tactics. Do you know if anyone's planning on filing a competing application?
I'm not sure if anyone's intending on filing a competing application. I did understand from my client this morning that Marathon had sold their interest to Permian, and so that might be a change where Permian may decide to file an application, but I can't speak on behalf of any of those parties.
Right.
Unfortunately, I can just say what my client has told me this morning.
I just thought you might have heard. Let me ask, from all the parties that are objecting, is anyone planning on filing a competing application?
Yes, Mr. Examiner, Powderhorn is planning to file a competing application.
And Powderhorn is an operator here in New Mexico?
Yes.
Okay, thank you. Are there any others that are?
No, Mr. Examiner, the basis of EOG's objection to this application is related to existing well bores in the area and concern over anti-collision measures. So that's the basis of our objection, and we're hoping to work through that with the applicant.
Interesting, thank you. So in other words, you'll try to get them to adjust where they put their well and have they drill it? Okay, I see.
That's correct.
And then you would withdraw your objection. Okay.
That's correct.
And Ms. Hardy, since I didn't hear anyone else, I didn't hear from anyone else with their objection, because Ms. Bennett, what was your objection based on?
Our objection is based on the development plan. And at this point, I am not sure whether Avant is going to be submitting competing applications. I'm not saying they are or they aren't. I don't have any information on that, so I can't answer the question.
Okay, I understand. Thanks. So Ms. Hardy, when would you anticipate filing your application?
So Powderhorn is sending out its well proposals this week.
Okay.
And so allowing for the 30 days then to file, I think we would be on the first February docket.
Got it. Okay. Well, that's good to hear. Thank you for telling me that. So Ms. Luck, what I'm going to do is I'm going to set this for a contested hearing in February. And then if you want to have another status conference before that, that's fine. You can move your case to that, whether it be December docket or January status conference docket for a final status conference. But I did note in my notes from the last October status conference that I said this was going to be the final time that I would continue this without setting a contested hearing. So if I'm not mistaken, there's one docket in February for a contested hearing, and that would be February 10. So please check with your client and your witnesses. But we're going to issue a pre-hearing order for February 10. If for some reason that is just not works, submit an affidavit from a witness saying why they can't participate on February 10. And I think we might have February 26 as a backup as the second February contested hearing docket.
Okay, thank you very much.
Of course. Is there anything further from Ms. Hardy?
No, thank you.
Ms. Bennett?
Nothing further. Thank you.
Any other party? No. All right, we're off the record in that case. Let's move on now to Powderhorn operating. Oh, interesting. We were just talking about Powderhorn. This is 25610. Entries, please.
Good morning, Mr. Examiner. Ben Holliday with Holiday Energy Law Group on behalf of the applicant, Powderhorn Operating.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2, and Avant has objected to this case moving forward by affidavit.
Thank you.
Mr. Examiner, Dana Hardy on behalf of Permian Resources Operating, and we are monitoring this case only.
Thank you.
Good morning, Mr. Examiner.
Good morning.
Go ahead. Ladies first.
Thank you. Good morning, Mr. Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Marathon, and we entered an appearance and objected. We do plan on sending out competing proposals regarding this acreage.
Can you tell me more about when you say we plan on sending out? Can you be more specific?
I mean, that's pretty much all I have at this point. I did get a little bit of an update from Marathon. They just got title back, so proposals are in the works being prepared, but they have not gone out yet. Once those proposals go out, we'll let them run their course, the 30 days, and then we will file competing applications 30 days after those proposals going out. So.
Okay, all right, thank you. Mr. Suazo?
Yes, good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak appearing today on behalf of Cimarex Energy, Magnum Hunter, and Coterra Energy. I'll just refer to them as Coterra for sake of ease going forward. And Coterra is planning on submitting competing applications as well.
Can you be more specific about when?
I can before the end of the month, so that would make it next week.
That's when you'll send your proposals out.
I thought proposals had already gone out, but if not, then yes, they'll send those out next week. If they have already gone out, then we'll be submitting the competing applications next week.
Okay, I wasn't saying that proposals had been or had not been. I was just asking you if you knew whether proposals had been sent.
I think that they are planning on sending proposals by the end of the month, now that I look a little more closely at the notes. So I think that might be, might need to clarify that. So proposals will go out next week.
Okay, very good. Thank you. So we have proposals from, and are there any other entries of appearance before I continue?
Mr. Examiner, Jim
Yes.
representing Kaiser Francis Oil Company.
And you objected?
Objected.
I'm sorry, I didn't hear you.
Kaiser Francis objected to the hearings.
For what purpose?
They are checking to see, and I was just informed of this, of any other parties making a proposal. They did not like Powderhorn's development plan, so they'll be interested in the Marathon and Coterra proposals.
Okay, thank you.
Mr. Examiner, I did want to just let you know that Avant is planning on filing competing applications as well. And in terms of your question about the timing, I unfortunately don't have that information. I don't know if their proposals have been sent out.
All right. Mr. Holliday, it sounds like this is getting to be crowded here. And I hear that 3 different operators are planning on competing with your proposal.
Yes, sir. That should be an interesting outcome. There's a pun about a hornet's nest here that I'm not going to make on the record, but yes, my understanding is that Marathon has not sent the proposals yet. I hear that they're going to. My understanding is Avant has sent counter proposals for this case.
Okay.
And then just one more interesting fact: there are 2 Bone Spring cases that were originally set for the November docket. They have been objected to that cover this same acreage.
Mm-hmm. And are you talking about 257, 53, and 54?
Yes, sir. So I expect those to be joined together on this as well.
And who is the operator for the applicant for those 2 cases?
It's also Powderhorn operating.
You mean 25610 should be joined with 257, 53, and 54?
Well, the Bone Spring cases overlap the Wolfcamp case.
Yeah.
And at least Coterra has objected to both. And so I would expect those to be considered at the same time or not. I mean, it's at the division's preference, obviously.
Okay, so I have notes here that I was going to ask Freya or Mada-E to join 25610 with 257, 53, and 54. Are they on another docket, those 2 cases?
Yes, sir. They were filed a month after, so they're not up yet. That's the.
I see. Okay. And you're representing Powderhorn in those cases too?
Yes, sir.
Oh, okay. All right, got it. And are these competing or are these potentially, or are these proposals from Avant, from Coterra, and from Marathon, are they all competing with just one formation or both formations?
I'll certainly, allow myself to be corrected. My understanding is that the objections we've just discussed relate to, and the counter proposals we've discussed from Marathon, Avant, And Coterra would be for the Wolfcamp case. The only party that I believe that, so that would be 25610. The only party I believe that has objected to the Bone Spring cases has been the Coterra group. And I am not aware if they've sent counter proposals or not on those properties.
Okay.
I can clarify that, Mr.
I was
Examiner.
hoping you would. Go right ahead.
Sure. So as I understand it, Coterra is prepared to send the Wolfcamp proposals out next week. However, with respect to the Bone Spring, they're going to send those out sometime in December.
Okay, thank you very much.
Mr. Examiner,
I was going to come to you next.
thank you. I did file an entry of appearance on behalf of Avant in the first Bone Spring case that was discussed, 25753, just this morning. And I wasn't aware of the case 25754, but we will be filing an entry of appearance and objection in that case as well.
Do you think your client Avant will will have competing proposals for that formation as well?
I'm not sure about that. I only learned of these cases yesterday.
All right. And let's see, Ms. Vance, you said you're going to have a proposal for the Wolf Camp. Are you going to have proposals for the Bone Spring as well?
I'm not sure. I'm looking through my email to see if I got any reference to Bone Spring. To my knowledge right now, it's just going to be Wolf Camp.
I see. Okay. Wow. All right. Sounds good. So Mata E, will you join those three cases for the purposes of a contested hearing? And Ms. Bennett, Mr. Suazo, and Ms. Vance, when you do file your competing applications, would you please file motions to join those three cases, or at least, the proper formation case, so that we can keep things straight here. Mr. Holliday, do you want to set a contested hearing down the road, or what?
I think our preference would have been to grab that February 10 date. It sounds like that's maybe spoken for. So I think there is going to be a change of position. I think there's deals to be made here, but our preference would be to set a contested hearing and then let that shake out as it's going to shake out.
All right. So based on what we're hearing today, with proposals going out in the next period of time, the 30 days would be by the end of the year approximately, then applications filed. It sounds like February would be the first time any of these competing applications would be ripe for notice. What if we did a pre-hearing order for February 26?
I'll check with the Powderhorn guys. I think that will be okay.
Okay, sounds good. What we'll do, and would you be prepared to present all three of your cases on February 26?
Yes, sir.
All right, I thought so. All right. Then we'll issue a pre-hearing order for those three cases for Powderhorn, February 26. And then once we get that, we can amend that pre-hearing order to add the competing cases as they're filed. Is there anything else, Mr. Holliday?
Nothing from me. No, sir.
All right, thank you. Mr. Suazo?
I think that Coterra would prefer later than February 26th under the circumstances and given, the holidays and everything else that are coming up. So I think that, that's the very earliest that, the cases could be heard, but practically speaking, given the positions of the parties and, all that needs to go out with the proposals and applications, I think, March would be, realistically speaking, the earliest this could happen. Sounds like Ms. Vance agrees with that.
Mr. Holliday, they're your cases. How do you feel about it?
Well, I'll just ask you a procedural question. If we were to hold the 26th date, could I have an opportunity to confer with Mr. Suazo and Ms. Vance about those dates? Yeah.
Sure.
So I would say my preference would be to hold the 26th date because Powderhorn is interested in moving this along as quickly as possible. And then I will confer with council and then let you know or let the division know if there's a need to change it.
Sounds like Ms. Bennett should be involved in that.
And Ms.
this
Bennett too, yeah, I'm sorry.
discussion as well. So why don't we do this? We won't issue the pre-hearing order tomorrow. What we'll do is we'll wait to hear from you, Mr. Holliday.
Okay.
They're your cases, so I give you preference on, how quickly we hear them. How about we have a deadline of Tuesday of next week to hear from you?
Yes, sir, that's plenty of time.
All right. You happen to have that date handy for next Tuesday?
Oh, gosh. Pull up the calendar.
It's the 25th.
Thank
Yeah,
you.
yeah.
All right, so we'll have a deadline to hear from Mr. Holliday on behalf of all the parties, whether that February 26th date is preferable or the 2 dates in March that we have available. And I think these were mailed out. I don't know if they were, would be March 10 and March 24. So those are the alternate dates in March. I wouldn't want to go past March, though.
Right.
All right. Anything from you, Ms. Vance?
Yes, so I just want to confirm that Marathon will be proposing both Wolf Camp and Bone Spring.
Okay.
And also wanted to, along with Mr. Suazo, we would prefer a date out in March or later. And I understand you said you didn't want a later date, but there's a lot of moving parts here, and it's Marathon's preference to push for a contested hearing in March or a later date than that.
Okay.
Thank you.
Well, March is 4 months away, so that should be enough time for the parties to get their acts together. Ms. Bennett, anything further?
Nothing further. Thank you.
Thank you. If there's nothing further, then we'll be off the record in that case. And I think Mr. Holliday will hear your other 2 cases coming up, I guess, next month, if I'm not mistaken.
Yes, sir.
And that'll be a good chance to hear about the proposals and the applications from the other parties as well. So, all right, we're off the record in that case. Let's move on to Sarvis Permian 25667 and 25669.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant Sarvis, and I can probably make this very quick. We are going to be dismissing these 2 cases.
All right, that makes that easy. Thank you. So I won't hear any
Yes,
other
thank you.
entries, although there are a lot of entries of appearance. Maybe I don't think there's any point that you're going to be dismissed. All right, so we're off the record. And when we're going to get that, Miss Vance?
Shortly today.
Okay, sounds good. Thank you. All right, let's move on to Mac Energy 25698.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant Mac Energy.
Thank you.
And Jackie McLean with Hardy McLean representing MRNM.
And I believe these 2 cases, when I say 2 cases, I didn't call your case, Ms. McLean, but.
No, yeah, we've had the status conference on that earlier this month.
And I believe these are set for January 27th.
Correct.
All right, sounds good. Ms. Vance, what is it that you'd like to tell me?
I mean, this was already set, but the only thing that I would state on the record is, and we kind of got into this at the last status conferences. At this point, regarding the overlapping acreage between the 2 contested cases, MAC does have a agreement in the works with XTO, so they will have the working interest control in the overlapping acreage. And to Ms. McLean's point at the last hearing, regarding wasting the division's time and, not going to a hearing if we don't need to, I would just state that we're going to present that at the contested hearing. And I'm not sure that there's really much more to do with these cases since we've got that agreement that's in the works right now. And we'll be able to show that MAC has the working interest control in the overlapping acreage. So just wanted to provide some color. Thank you.
And Ms. Vance, before I go to Ms. McLean, who may have a different opinion, why is that a controlling issue?
Because it's a part of the factors and it's one of the primary factors that the division looks at when they are reviewing or looking at contested and in particular overlapping contested acre or competing cases. Who has either the majority working interest control or ownership. And in this case, we'll be able to show that MAC has all of the working interest control in the overlapping acreage.
So correct me if I'm wrong here, because I want to understand your point fully. So let's say that we have two proposals and they overlap in one area. But then there's the other area outside that overlapping area. Does the division look at just who has the majority of control in the overlapping area, or does it look at the percentage of interest in the whole proposed areas?
They will primarily look at, and I am trying to find in my notes on the order that discusses overlapping factors that the division looks at, but the division primarily, they're going to look at the overlapping acreage because if a party has the working interest control in their own acreage, they can do whatever they want with it. But the contest is over the overlapping acreage.
So what I understand you're saying is MAC has 100% interest in some area, and then it may have, depending on whether you finalize this agreement or not with this other party, or XTO, I think you said?
That's correct.
If you are able to finalize the agreement with XTO, then you would have basically the control of not only the overlapping area, but of course your area as well. That's what you're saying.
That's correct. That's correct.
And you're saying that, okay, well, let's see what Ms. McLean has to say.
I disagree with everything that Ms. Vance just said.
Yes.
First of all, we are also working on XTO. As I said the last time, there's lots of potential deals here. Secondly, I believe we had a case earlier this year with Fiero where the division made clear that you look at the entire spacing unit and the interest ownership over the entire acreage, not just one particular tract, which Ms. Vance continues to want to do in this case as well as the Fiero case. So I believe, we are ready and we're proceeding forward to that January 27th contested hearing. I don't think it will be a waste of anyone's time because we have very valid reasons to want to develop our acreage. And we are also working on a deal ourselves.
Okay, thank you. As I thought, Ms. Vance.
I've got one other thought that I would like to respond to Ms.
Oh, go right
McLean.
ahead. Sure. Let's hear.
Okay, well, the overlapping factors, if you'd like to reference them, Mr. Hearing Examiner, that's order number 21416.
And is that a commission? I'm sorry, Ms. Vance, commission order or division order?
I believe that's a division order.
Okay, 21416. Okay.
That's correct. One, I would say that I want to be clear that the case that Ms. McLean is referencing regarding Fiero that has nothing to do with the case that we're talking about right here. And in that case, it's one set of competing applications and a JOA that's involved, and those are distinguished from what we're dealing with right here, which are two compulsory pooling cases that are overlapping. So again, that's distinguishable. It's my understanding also that XTO has already communicated to MNRM that they will not be supporting them, that they're going to be supporting our client. So the idea that there are all of these deals to be made, I'm not sure when the last time Ms. McLean talked with her client, but it's my understanding that XTO has communicated to them very clearly that they are not going to be supporting them, that they will be supporting MAC. Thank you.
Can I also chime in with my thoughts?
Okay, all right.
We're just going to go back and forth. I'd like to say that the order number R21416 is the BTA case that describes the competing factors. And that also had to do with the JOA. So, a lot of things have to do with JOAs, and the concepts still apply to competing or contested compulsory polling applications. I talked with my client yesterday. I don't know, I don't think that that's really important when what people are saying. I'm sure Mac is telling Ms. Vance one thing. I'm getting told another thing by my client. At the end of the day, we have a contested hearing date set. Either they show up or they don't.
Okay. All right. So Ms. Vance, I understand your points. Thank you very much. Ultimately, that's what the contested hearing is about, is to work these out with evidence. And so we look forward to hearing more. And there's plenty of time between now and then to work out any of these differences, if they can be worked out. Is there anything further, Ms. Vance?
No, we look forward to the contested hearing. Thank you.
All right. And Ms. McLean?
Nothing from MRNM. Thank you.
All right, thank you very much. All right, let's now move on to Admiral Permian. These are two cases filed just in October, mid-October, 25708 and 25709.
Mr. Examiner, Dana Hardy on behalf of Admiral Permian.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador. And we did enter an appearance and objection to both of the cases. We are withdrawing our objection to the Wolf Camp, but we will be sending out proposals for the Bone Spring that compete with Admiral's cases.
Oh, thank you, Ms. Vance. Let me just write this down. So Ms. Hardy, then it sounds like you would be able to move forward on one of these cases by affidavit?
That's correct. And that would be 25709.
09 is the Wolf Camp?
Correct.
Excellent. Why don't you move that to the December docket? December 4, we'll make room for it because we'd like to move it along.
And I think actually Admiral would be fine with the first January docket, if that's acceptable.
You'd rather not,
I think-
so you'd rather not do December?
I think they
Oh,
prefer
well, that's
January.
different. Okay, then do the January. I thought you wanted
Okay.
to move it along.
No, yep, January sounds great.
Okay, so you're gonna continue this case for hearing by affidavit to the first January docket. I think it's the 4th or something.
The 8th.
Oh, is it the 8th? January.
Yes.
January 8th, hearing by affidavit. And Ms. Vance, you said you were sending out competing proposals for the Bone Spring. Any idea when?
It should be soon. My understanding is that we will be filing we should be filing the applications for the January 8th docket. But I can follow up with the division to confirm, but that's my understanding.
Okay.
I think maybe it would be appropriate to do another status conference in January if Admiral, if that works for them.
So Ms. Hardy, I leave it to you. It's your case and you know now that it'll be a competing case.
Yes.
What would you like to do?
I think Admiral would prefer a contested hearing date in February.
Okay. We have two. There's the 10th and the 26th. The 10th would be a trailing docket. The 26th would give you more time. And you want to try it for the 26th?
I think the 26th would be
Sounds
fine.
good.
Thank you.
All right. We'll issue a pre-hearing order for the 26th. And Ms. Vance, when you do file your competing proposal, would you file a motion to consolidate it with 25708 and amend the pre-hearing order?
Would you like that as a separate filing, or can I do that as a part of the application?
As a part of the application is fine with me, as long as the law clerk would see it and recognize it as what it is. That's all I care about.
I will make sure to follow up.
All right, perfect. Thank you. Is there anything else, Ms. Vance?
Not from me, no.
Ms. Hardy?
No, thank you.
Okay, wonderful. We're off the record in those two cases. I'm just curious, Ms. Hardy, why do you think January 8th is a better day to hear your affidavit than December 4?
I think that I'd have to go. I think that date just worked better for our witnesses
Oh,
if
your
they need to be
witnesses, okay.
available.
All right.
Yeah.
Well, look, if it's within your control to move it to either docket you want to. I was just
Okay.
trying to give it priority.
No, I appreciate that very much.
Because the December is full already,
I know.
but I'd be happy to add it to that because this case has been filed a while ago and I'd like to move it along, but
I'll confirm with my client.
if you find that the December works, if you find that December works for you, you're authorized to move it to December, but please send an email to Freya and let her know our discussion and that I said that I would put it at the beginning of the December docket
Okay,
to make sure it's heard.
okay, thank you. I appreciate that very much.
We're off the record in those two cases. Let's move on to yet another Powderhorn case. This is 25722.
Dana Hardy on behalf of Powderhorn.
Excellent.
Miguel Suazo with Beatty and Wozniak on behalf of Coterra, Magnum Hunter, and Cimerex.
And you objected?
Yes.
Okay, and what are you trying to get out of this?
Well, I think that Coterra had some issues with the development plan that was proposed. I know that the parties are still negotiating terms, but at this point, not uncertain as to whether or not they'll be fruitful. Coterra is prepared to take this to a contested hearing, and we'll be submitting competing applications.
So it is. So in other words, if your negotiations don't go as hoped for, you would submit proposals.
Well, I think that we're planning on submitting proposals, you know, if we don't come to terms in the near term, and I don't think that's going to happen. So my understanding is the client's preparing the proposals to go out for some of these next week, and just like the other case, the other Powderhorn case, also in December, and then we'll send out applications, you know, once the deadline passes, once the proposals have been submitted.
Okay, and that would be for Coterra. Well, I guess Cimerex and Coterra are the same thing now?
Correct.
And what about Magnum Hunter? Is that all the same?
They're all under the Coterra umbrella.
Okay, so we can just say Coterra then. Okay.
Yes.
Okay, I see Ms. Hatley.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating, and we are objecting to this case.
And that's as rare as Ms. Kessler's objection is. And why are you objecting?
We're just keeping you on your toes this morning,
Yes,
Mr.
you are.
Examiner.
Why are you objecting?
We are hoping to negotiate with the parties, but we haven't decided exactly what our path forward will be.
Okay, all right. Okay, excellent. Yeah, when I saw your objection, I was quite surprised. Okay, Ms. Hardy, how do you want to proceed?
Excuse me, Mr. Examiner, George
excuse-
Kessler on behalf of EOG Resources monitoring this case.
Thank you, Ms. Kessler. Ms. Hardy, how do you want to proceed?
As you can see, Mr. Examiner, there are a lot of moving parts here. So Powderhorn would like to set this case for a status conference on the December status conference docket.
Okay, I don't have that date in front of me. Do you? Oh, wait a second, I do. 23rd.
Is it the 23rd?
I thought it was. It's written here. Maybe it's not.
Oh,
18th. I'm
18th,
sorry.
that sounds
I'm sorry.
better.
I'm sorry, yes, it is correct. 18th.
Yes, 18th.
All right, so you'll move it, you'll continue it. Okay, very good. Then we'll have a status conference on 12/18 and we'll see how this is proceeding.
Great, thank you very
Anything
much.
else, Ms. Hardy?
No, thank you.
All right, then we're off the record in this case. We have the last two cases, Avant Operating 25747 and 48.
Good morning, Mr. Examiner, Dina Bennett on behalf of Avant Operating.
Thank you.
Jackie McLean.
Good morning,
on
Mr.
behalf of
Hearing
Permian-
Examiner Paula Vance on behalf of, good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Matador. And we entered an appearance and objected at this point.
Before I go to Ms. McLean and Ms. Luck, what's your objective here?
Right now, I believe that Matador and Avant are negotiating. So to my knowledge, Matador is not planning on sending out
Okay.
competing proposals.
All right, and I'll come to you, Ms. Bennett, in just a moment. Go ahead, Ms. McLean.
Yes, Jackie McLean with Hardy McLean on behalf of Permian Resources, and we've objected.
And your objective is?
We are going to file competing applications.
Very good, thank you. And Ms. Luck.
Good morning again, Mr. Hearing Examiner. Caitlin Luck appearing for WR Non-Op LLC, which is Waterloo's non-operating interest, and not objecting in this case, just observing and preserving rights. Thank you.
Perfect, thank you, Ms. Luck. Ms. McLean, before I go back to Ms. Bennett, any ideas on when you might be sending out proposals if you haven't already?
I believe they've already gone out, and I believe that we're going to be filing for the January 8th docket.
I understand, perfect, thank you. Ms. Bennett.
Thank you, Mr. Examiner. So both MRC has less than 3% in this unit, and Permian Resources has 4% approximately in the unit. And so Avant is ready and wants to go to hearing. This is not something that should be delayed. I've reviewed the Permian Resources proposal, and they're proposing wells that extend into section 10 where Permian owns nothing and Avant owns 78%. So Avant is ready. We're going to go to hearing.
Okay.
And so if in fact Permian Resources does in fact file competing applications, then any of the 2 January dates will work for Avant, January 13th, January 27th, and even the February 10th.
Okay.
Date. And what I would ask though is to set a contested hearing, but also I would like to file a continuance for these 2 cases to the December 18th docket.
Of course.
So that we can have a status conference to see if Permian follows through with its competing applications.
You have authority to do that, of course. So, Ms. McLean, if we set this for a 27 January contested hearing, does that work for you?
I believe we have several other contested hearings that date already.
But you know how these are.
Yeah,
We
I
can
mean,
set
that's-
100 of them and they'll all go away.
That's fine with me. My preference would be, I mean, I have drafted the applications.
Okay.
I don't know why everyone's doubting my follow through today, but I'm going to be filing. I think so we don't waste time and come back on yet another status conference. What would make more sense is, we file the applications, they can object, they'll automatically get on the status conference before this contested hearing date, so they can see if we filed by checking the docket. And I can also send Miss Bennett a copy if she'd like.
But my question to you was, does the January 27 contested hearing date work for you?
I would have to ask the clients, because I don't know if we have the other Permian Resources contested hearing that day,
Sure.
but this is another set of witnesses, so I would have to make sure that they're available.
Of course.
Mr. Examiner?
Yes.
I too have additional
Right.
cases on January 27th, and I am fully prepared to move
Okay.
forward. And the division did send out the proposed contested hearing dates well in advance of today so that we could be prepared to discuss hearing dates. And we did that with Avant. And Avant is ready to move forward. So it'd be Avant's strong preference to have a pre-hearing order issued for January 27th.
Got it. So Ms. McLean, as you know, I do give preference to the to the applicant. If for some reason your witnesses are just not available, please file a motion with an affidavit showing us why we would not be able to have it on the 27th. And then we might move it to, if it works for Ms. Bennett, February 10, which is not that far after. It's less than 2 weeks after, or maybe 2 weeks after the January 27. But we'll issue the pre-hearing order, and we'll wait to hear from Ms. McLean if there is a conflict with her witnesses. Is there anything further, Ms. Bennett?
Nothing further. Thank you.
Sounds good. Ms. McLean?
Nothing from Permian Resources.
Ms. Vance?
Nothing from me. Hi from San Francisco.
Okay, well, I'm glad you're having fun.
I'm on military duty, so.
Okay, well, that could still be fun, I guess. Depends on how you look at it. So if
True.
there's nothing else, then that's the last of our cases today. And I thank everyone for their participation. We're off the record.
Thank you.